Building upon the previous section's discussion on conflicts of interest, this section examines one of the most regulated areas in modern real estate practice: the disclosure of financial interests, marketing service agreements, MSAs, and affiliated business arrangements, AFBAs. These relationships are common in real estate transactions, as brokers often collaborate with lenders, title companies, inspectors, and other settlement service providers to streamline the closing process. However, because these relationships can create financial benefit or referral incentives for the licensee, they must be disclosed in writing to ensure full transparency and compliance with both federal and Arizona laws. At the heart of these disclosure requirements lies the Real Estate Settlement Procedures Act, RESPA, a federal law codified at 12 U.S.C. Section 2607, which prohibits unearned fees, kickbacks, or referral payments in connection with federally related mortgage loans. Under RESPA Section 8, any licensee or brokerage that has a direct or indirect ownership interest in a settlement service provider or receives compensation for referring business must disclose that relationship to the consumer through an affiliated business arrangement disclosure. This law works in tandem with ARS Section 32-2153A3 and Commissioner's Rule R4-2-8-1101A, both of which require honesty, fairness, and full disclosure of any fact that could influence a client's decision-making. A financial interest exists when a licensee, broker, or any immediate family member has ownership, investment, or profit participation in a related service company used during a real estate transaction. For example, if a broker owns 20% of a title company or a property management firm, that interest must be disclosed in writing before or at the time of referral. The written notice must clearly state the nature of the relationship and the fact that the client is not obligated to use that provider. Failure to disclose such an interest could result in disciplinary action from ADRI and fines under RESPA Section 8A, which prohibits undisclosed financial gain from settlement services. A marketing service agreement, MSA, is a business arrangement in which one party provides advertising or promotional services to another in exchange for compensation. In real estate, this often involves a brokerage receiving payment from a lender, home warranty company, or title agency for joint marketing activities, such as placing promotional materials in a real estate office or sharing advertising costs. Although MSAs are legal under specific conditions, they are closely scrutinized by regulators to ensure they are not disguised referral fee arrangements. The Consumer Financial Protection Bureau, CFPB, and the ADRE require that any payment be strictly proportional to the fair market value of the marketing service provided. For example, if a lender pays a brokerage $500 monthly to display its brochures in the office lobby, the payment must reflect the actual value of the advertising space, not an inducement for referrals. In Arizona, R4-28-1101B reinforces this by requiring written disclosure of any relationship or compensation arrangement that could influence a licensee's objectivity. Licensees must always disclose to both their client and the consumer being referred when a financial benefit or ownership interest exists. A simple verbal disclosure is insufficient. The disclosure must be written, dated, and retained in the broker's transaction file as part of the record-keeping requirement under ARS Section 32-2151.01A. A practical example helps illustrate this concept. Suppose a real estate brokerage has a joint venture with a title company. When an agent working under that brokerage refers a buyer to the affiliated title company for escrow services, the agent must provide an affiliated business arrangement disclosure form before or at the time the referral is made. The form must clearly identify the nature of the relationship, disclose any ownership interest, and include a statement that the consumer is free to choose any other title company. The buyer then acknowledges receipt of the disclosure by signing it. This document protects all parties and ensures the client's choice is truly voluntary. Another example involves an agent who also owns a home inspection business. If the agent refers their own company for an inspection during a transaction, that dual role creates a financial interest that must be disclosed to the buyer in writing before scheduling the inspection. Even if the agent performs a professional job, the failure to disclose the ownership interest would violate R4-28-1101A for lack of honesty and RESPA Section 8B for unearned fee risk. What this means, the risk. A licensee or settlement service provider violates RESPA 8B if they charge a fee but don't actually perform a service for it, add a markup to a third-party fee without providing additional services, split fees with someone who did not perform work, collect administrative, processing, transaction, or junk fees that don't correspond to real, itemized, documented work. The timing of these disclosures is critical. They must be made before or at the time of referral, not after services have been rendered. This timing allows clients to make informed decisions about whether to use the recommended provider. A delayed disclosure may appear deceptive, even if unintentional, and can lead to investigations by both ADRE and the Consumer Financial Protection Bureau. CFPB licensees must also avoid exclusive marketing arrangements that limit consumer choice or provide compensation tied to the volume of business referred. Such practices may be considered kickbacks under federal law. Instead, licensees should structure MSAs as transparent, contractual relationships for legitimate advertising or promotional services, with payments based solely on fair market value and without regard to referral numbers or transaction volume. What an MSA is. An MSA is a contract in which a real estate brokerage agrees to pay a title company, mortgage lender, or other settlement service provider for advertising or marketing services. For example, displaying the lender's brochures in the brokerage office, featuring the title company on the brokerage's website, co-branding marketing materials, hosting joint educational events. Why MSAs are risky? Because MSAs involve payments between parties who can refer business to each other. They pose major RESPA Section 8 risks. The CFPB has warned that many MSAs are actually disguised referral fee arrangements, which are illegal. Arizona courts and ADRE disciplinary actions emphasize that even the appearance of undisclosed financial gain can harm public confidence in the real estate profession. In CFPB Prospect Mortgage, LLC, 2017, the CFPB fined multiple entities for using MSAs and lead agreements as illegal referral channels. Although this was a national case, it serves as a cautionary example for Arizona licensees. If compensation is tied in any way to consumer referrals, disclosure is mandatory and the practice may be illegal. Review summary: licensees must disclose in writing any financial interest, MSA, or affiliated business arrangement connected to a real estate transaction. Under RESPA Section 8, ARS Section 32-2153, AA3, and R4-28-1101, the disclosure must clearly describe the relationship, the licensee's ownership or compensation interest, and the consumer's right to select alternative providers. Disclosures must be made before or at the time of referral, documented in the transaction file, and presented in clear, non-misleading language. Failure to do so can result in civil penalties, ADRE discipline, or federal enforcement. Discussion: why must a licensee disclose an ownership interest in a title or escrow company? Answer: because the ownership interest creates a financial benefit from the client's choice of service, which must be disclosed under RESPA Section 8 and R4-28-1101E to maintain transparency. When must a marketing service agreement disclosure be delivered to the client? Answer: before or at the time of referral to allow the client to make an informed decision about using the recommended service provider. What must an affiliated business arrangement disclosure include? Answer: the nature of the relationship, the percentage of ownership or financial interests, and a clear statement that the client is not required to use the affiliated business. Closing remarks transparency protects trust. Financial relationships in real estate are not inherently unethical, but failing to disclose them is, whether it involves shared ownership in a title company, participation in a joint marketing agreement, or compensation for referrals, licensees must always disclose fully and in writing. Doing so ensures compliance with both Arizona law and federal regulations, while preserving client confidence and professional integrity. The rule is simple. If you benefit financially from a recommendation, disclose it before the client acts on it.